Hello, everybody. My name is TJ Scott. I'm a Minnesota estate planning attorney and the owner of the law office of Timothy J. Scott. I've been doing estate planning now for quite a few years, and I love it. And I'll talk more about what I love about it here. But it's definitely a passion of mine to help people get their estate plan in place. Tonight, I want you to be here present with me, and I want to make sure that you are getting the best information possible, that you're able to absorb what lessons and what information I have here to share with you. So I really encourage you to turn off distractions. If you have another tab open or another window open, I really encourage you to just turn it off for right now and give yourself this time that you've set aside to educate yourself about the issues of estate planning and how to get a great estate plan in place. And I promise you, your future self is going to be very happy that you took the time to educate yourself here this evening. And I want you to stay with me all the way through the end of the presentation. It will be about an hour presentation. It may run a little bit longer, especially if we have some great questions along the way. But I want you to stay with me because I have a couple of offers to make to you throughout the course of the presentation, in particular at the end of the presentation. One of those things is how you can have a free virtual one-on-one meeting with me to talk about the things that you have and the people that you love and how you can protect them with an estate plan. Plus, I have a bonus gift that's going to make it even easier to get a great and personalized and tailored estate plan in place. But first, I want to hear from you. So again, if you can find the chat function, if you can find the Q&A function and let me know. Actually, hold on. Maybe I have a poll. Let me see if I can post a poll. No, it's totally not going to happen right now. Not going to happen. If you can find the chat box and tell me, do you have an estate plan in place right now? I have some estate planning tools and some estate planning items listed here, but those items in and of themselves aren't a complete estate plan. None of those individual items is enough to have a full estate plan. I see somebody saying chat function is disabled. Not sure if that's the case for other people as well, or maybe it's just a problem for this person. I hope not. I hope everybody can use the chat, and it's okay if you can't. Maybe you can just respond here. Chat disabled. Interesting. What interesting problems we discover sometimes when we use technology to try and make things happen. I'm not going to be able to get the chat function working. Just use the Q&A function if everybody's saying mine's disabled, mine disabled. Well, I appreciate that. Thank you, everybody, for letting me know. And unfortunately, I'm not going to be able to get it enabled. That just means keep on using that Q&A function because that's really helpful. I can see what you're saying pop up in that Q&A function. Um, I see. Attendees can chat. We got there. I think I figured it out here. So now you should be able to put your messages in chat. But I want to hear here, do people have an estate plan? Yes, and Gretchen, that's fantastic. Thanks for posting in. Um, Even if you haven't written an estate plan before, even if you don't have a will, even if you don't have a trust, uh, the state has written an estate plan for you. And we're going to talk here this evening about that state written estate plan, the plan that the state thinks that you want to have in place. And we'll talk about what that means for you and for your family here this evening. So even if you haven't taken the affirmative step and written an estate plan for yourself yet, you're not alone. Something like 68% of Americans haven't written their estate plan yet. And I'm curious to hear from you again now that we got the chat working. Thanks everybody for the enthusiasm in chat. Why, if you haven't written an estate plan yet, does one of these items here resonate with you? Maybe you've been too busy or you feel like you're too young to need an estate plan. You're worried about estate planning being too expensive. Or I've heard before, sometimes people are just worried about jinxing themselves. It feels like, I'm going to write that estate plan and then something's going to happen and I'm going to be gone. And I see somebody saying they're not married and maybe they don't feel like they need an estate plan because they aren't married yet. And I think that goes to being too young. That sometimes we feel like we're too young, or the time just isn't right, and I'm going to wait until a specific moment, and that's going to be the best time to plan my estate. But the reality is, there are a lot of estate planning things that you may want to get in front of, especially matters regarding your healthcare or regarding who would make decisions for you if you couldn't make decisions for yourself, that are really important to get in front of and get done as early as possible. I see somebody saying they don't know where to start, and that's a fantastic point, that this is an intimidating area. And sometimes we don't know where to start, and we don't know the best next step to take. And we'll be talking about that absolutely tonight. Somebody saying initially too young, but I had a child and I need to protect him. Yeah, absolutely. Having a child is a big moment, an important moment in anybody's life, and it makes estate planning have a special relevance and a special import, especially guardianship for that child. Somebody saying busy, expensive, and overwhelmed thinking about it. I totally understand. It is overwhelming when you're trying to take it all on by yourself. And that's why I really recommend having the right professional to help you, the right professional to guide you along the way. Thanks everybody for sharing and making this an interactive experience. So what are you hoping to learn today? Maybe you've done an online or do it yourself will, and you're wondering if that's going to cover your family when you need it to. Or maybe you're wondering, you wrote an estate plan 20 or 30 years ago, and you're wondering, is that going to be okay? Is that covering what I want to be covered? Is it going to take care of my family in the way that I want them to be cared for? Or maybe you just want to have a better understanding of estate planning in general, and you just want a better picture of what these different tools are and how the tools work together, and whether your estate plan is doing what you want it to do. And I hope that you'll share if there's something in particular that has you concerned, or in particular that you want to know, because I want to answer that here this evening for you, if I possibly can. You know, some questions may be too specific for me to address in a lot of detail here this evening. But if that's the case, I'll just encourage that you reach out to me and have a continuing conversation with me where we can talk about that and talk about your concerns and make sure that we get you answers to your questions. I see somebody saying, I'm here to learn about my part in planning for my parents and have information to bring back to my siblings. However, it will also help me plan for my own future when I get married and have children. Yeah, that's fantastic. And a lot of times, people are driven to do their own estate plan by what they see from their parents' estate plan. But I also see a lot of kids being the impetus for parents getting their estate plan in place. Kids saying, hey, mom, dad, have you taken care of this? It's something that's important, and I just want to make sure that you've taken care of this for me and my siblings. So it's great to have everybody here. And I do want you to know, everybody, you are in the right place here this evening. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online or fill in the blank will, but you're not sure if it's going to work for the people that you need it to work for when you're gone. And you're in the right place if you're nervous about how much this is going to cost. I'm going to talk about that. I'm going to specifically share numbers here at the end of our presentation, and I'm going to share some offers that will make it easier to get a great estate plan in place at the right rate. The reality is, our estate planning isn't about us. It's something that really occurred to me when I was writing my estate plan with my wife, is that I was never going to personally benefit from the estate plan that I was writing, especially the provisions about my assets and how the assets would go to my kids. And these are my five kids. Our oldest is Ben, and then Elizabeth is our second oldest. We have Margaret, Bridget, and George. George is the baby at 9 months. But that's who my estate plan is for. It's making sure that they're cared for, that we've taken care of it for them to make sure that they're in the best position possible at a moment that is sad, and that they're grieving, and that we don't want them to have to go through without having support. So what are we going to cover today? We're going to talk about what is an estate plan, and we're going to talk about whether or not We need an estate plan. Who needs an estate plan? We're going to talk about today. We're going to talk about the different tools that are available to plan your estate. We're going to talk about whether or not it's possible to DIY or do it ourselves. And we're going to talk about who can help me to plan my estate if I don't want to try and take it on myself. But before we do, I want to tell you just a little bit more about who I am and where I come from. So my name is TJ Scott, and I am an estate planning attorney. I'm located here in Bloomington, Minnesota. This is my family, my wife Tobin and our 5 kids. And we live in Bloomington. I work in Bloomington. I mentioned before that back here, this is France Avenue. We're on France and 494 in the Bell Bank building. I graduated from the University of St. Thomas School of Law. I graduated magna cum laude, which means that I was near the top of my class. I was on law review, things that typically set you up for a job in big law or some kind of big law firm. But something special happened to me the day after I commenced from law school. The day after I commenced from law school, my son was born. Our oldest was born, Ben. And sitting there in that hospital room with my wife and with Ben kind of clarified my wishes. It told me I don't want to spend my time downtown in some big law firm, 80 or 100 hours a week. I want to practice law in an area that's helpful to people, that serves people. And I was really lucky coming out of law school because I was able to find a place where I could do that. I worked with an estate planning attorney who had been writing estate planning documents for something like 30 or 35 years. She was able to tell me how to write a very good estate plan. She also showed me that an estate plan isn't just within the 4 corners of the document, that there's more to an estate plan, and it's really important that you address those things that are outside the 4 corners of the document in order to make sure that your client is going to get the value that they want from their estate plan. I see somebody saying adorable family. Thanks. I'm pretty partial to them myself. But that's really important that it's not just the document itself. It's not just the language in the documents that's important. Sure, that is really important, but making sure that other things outside of the document are done is equally important to getting the result that you want. Um, I'm going to start here talking about something that's difficult but may not apply to everybody. I'm going to be talking about guardianship. And this is extremely important if you have minor children. If you have minor children and you're raising those minor children, you know what those kids need. You're their parents or you're their guardians, and you're taking care of them and you know exactly what those kids need and the kind of support and the kind of people that they need around them. But if you haven't taken the time to name guardians for those kids, then if anything happens to you, a judge is going to have to decide what is in the best interest of those kids. And if the judge decides that the best interest of those kids is to go and live with Uncle Larry or Aunt Susan, well, Uncle Larry or Aunt Susan is where those kids are going to be raised. But this is something that you can take care of. If you're a parent of minor children, naming long-term guardians for your children is crucial. It's essential. You need to do it because you know where those kids are going to thrive uh, and uh, and who they belong with. So these are the instructions to judges, to things to consider about the best interests of children. And the judges will do their best, but the things that a judge considers to be within the best interests of the children aren't necessarily what the parents consider to be within the best interests of the children. Like I say, you know them, you know what's important to you in seeing them raised. So taking care and naming long-term guardians who are going to raise your kids until the age of 18 is essential as a parent and something that I hope that all of us get in place. Long-term guardianship is important, but short-term guardianship is important as well. And short-term guardianship is the best way to think of it is if something happens and you don't come home from date night, let's say that you have a babysitter watching the kids and you've gone out and had a wonderful night together, but for whatever reason, something prevents you from getting home. and time continues ticking. And at some point, that babysitter says, I'm not sure that mom, or I'm not sure that dad, or I'm not sure mom and dad are coming home, and I need to figure out what's going on. That babysitter may call the police. The police may show up to the house, and then it's a question: who gets to stay with those kids? It's probably not the babysitter. Babysitter's probably not going to have any kind of legal right to stay with the kids. And do you have documentation in place that says, if I have minor kids, those kids should go and stay with my mother, or those kids should go and stay with my sister, or those kids can go and stay with the neighbor? If you don't have legal documentation in place, unfortunately, for a lot of times, the police are going to decide that Child Protective Services is the best place for those kids. And this isn't to, deride Child Protective Services, but I think most of us don't want our kids spending any time with Child Protective Services. They want them to be protected, and it's important. And you can take care of this. You can get long-term guardianship in place. You can get short-term guardianship documents in place to make sure that those kids are well cared for. What about planning for incapacity? The reality is, all of us are going to die someday. And unfortunately, some of us will become incapacitated before we pass away. If we haven't taken care and made healthcare decisions in a legally documented way, or we haven't legally documented who we want making financial decisions for us, the state has a default way of deciding who gets to make healthcare, who gets to make financial decisions for us. And those processes are called guardianship and conservatorship. Guardianship and conservatorship are expensive court processes to decide who gets to make healthcare decisions and who gets to make financial decisions for us. They also tend to lead to a lot of conflict in the family. They lead to a lot of conflict because each member of the family needs to come forward and say, I think I'm the best person to make healthcare decisions for this person, and this is the reason why. And then another person, so sister says, I'm the best person to make healthcare decisions. Brother comes along and says, wait just a minute. I was closer to Susie, and I think I should get to make the healthcare decisions. And then mom gets into the picture and says, hold on just a moment. I'm the mom and I get to make healthcare decisions. And now all of a sudden you've got three people making arguments for why they're the right person to make decisions about life-sustaining treatment. It's a lot of conflict. It's a lot of expense in court, and it can be avoided, but you have to do some planning in order to avoid it. Who naturally receives your assets if something happens to you? This is a question that a lot of people have. And a lot of people are wondering, sometimes people tell me, I'm worried that the government is going to get my money if something happens to me and I haven't written a will. Luckily, that typically doesn't happen. The government is way down on the list to receive your money if something happens to you. Your spouse has priority, pretty high priority, depending on your situation. Your kids have pretty high priority if you have kids or grandkids from kids, that they get pretty high priority. If you don't have a spouse and you don't have kids, then it starts to go in a line of descent from your parents instead. So it goes up to your parents' level, and then down to siblings, and then down to nieces and nephews and grandnieces and nephews, and flows kind of like a waterfall from your parents' level. If it doesn't find anybody in your parents' line, it goes up to your grandparents' line and falls like a waterfall from there. So that's aunts and uncles and first cousins once removed, and looks for somebody to receive in that line. If it doesn't find anybody there, it even goes up to your great grandparents. So there's quite a ways to go. And at the end of the line is the government, that if it doesn't find anybody in your great great grandparents' line of succession, I think it is, then the assets escheat to the state, which means that they go directly to the state. But luckily, the government is pretty wise in knowing that we want our spouse to be cared for first, and if not our spouse, we want our kids to be provided for, and we want our kids or grandkids, somebody in our line of descent should receive first. And if it's not somebody in our line of descent, it's somebody in our parents' line of descent. And if it's not somebody in our parents' line of descent, somebody in our grandparents' line of descent. But that's not right for everybody. And sometimes we don't want our siblings to receive, or sometimes we want our kids to receive in a special way. And unfortunately, if you haven't taken control and written your estate plan to be carried out the way that you want it to be carried out, there's no guarantee that it's going to happen that way. In fact, the default way for people to receive is through a process called probate, and that's a court process called probate. And there are a few things to know. Probate takes a long time, it's expensive, and it's a public process. This slide demonstrates how long it takes to get through probate. It's like a web, it's like a administrative slow slog through the court process. Um, and in that slow slog, that takes at least 6 months here in Minnesota, more often something like 12 to 18 months. It usually takes about 6 months just to sell the house, for example, to have the house ready to sell when you're going through the probate process, with resolution only really happening at 12 or 18 months. Um, and through that slow slog, excuse me, there are all these costs that enter into it, all these fees and costs that enter into it. Things like attorney's fees and filing fees, bond premiums and executor fees, appraisal fees and creditors. All these things along the way start to bleed money away from the estate and away from what you have that should be going to the people that you love. So it takes a long time, it's expensive. In fact, we estimate here in Minnesota that probate costs something like 3 to 6% of the gross value of your estate. Just to show you kind of what that might look like for you, if you calculate the value of your home, I have here a house valued at 300,000. They also have a rental property. If you don't have a rental property, maybe you have a cabin, or maybe you have uh, some other kind of property, a family home, something like that. We have furniture and household goods. We have some automobiles that have a total value of $50,000. And then there's some business interests, or you could consider, maybe investment interest or something like that. All told, a total value of $730,000. Well, for that estate that's valued, the gross value of the estate is something like $730,000. We would estimate that the probate cost would be somewhere between 3 to 6% of that gross value. And just a 5% estimate, quick back of the envelope math for a 5% estimate, is that probate for that estate might cost something like $36,500. Probate is expensive. All those fees enter into it, not to mention the amount of time. If you're paying a mortgage on your home and you can't actually sell the house for 6 months, you're paying that mortgage and utilities and everything on the house without anybody being able to really live there or enjoy it. It can just drain the assets out of your estate. And that's not what you want. Probate's also public. So I have here the will of JFK, and in this will, which is public, it had to be made public in order to be subject to probate. We can see that he gave to his wife $25,000. Jackie Kennedy gave her $25,000 plus half of his property, but there was half of the remainder that went to someone else entirely. And I don't need to keep you in suspense. Half of his assets went to his kids. That means that Jackie Kennedy, you're able to see JFK's will and see the probate of his will to see that his wife didn't receive everything after he passed away. And instead, some of the assets bypassed his wife and went directly straight to his kids. And like I say, it's had to be made public because it went through the through the probate court case, alerting everybody to the fact that Jackie Kennedy was receiving assets, that his kids were receiving assets at the age that they were receiving assets, which is a really unnerving thought. The court believes that everybody has the right to see what's going on in the court, has a right to see and to transparency in the court. But this level of transparency is unnerving to think that somebody out there could be seeing what assets we had at our death and what assets are going to our young kids is just really unnerving and brings up the concern that they might be might be people out there that could take advantage of that information. The good news is court is optional. You don't have to go through the guardianship process, the guardianship court process, and your family doesn't have to go through the guardianship court process. There's a document for that called the Healthcare Directive where you can capture that. You can take control of that process, name your own agent to make healthcare decisions for you. And in a second part, you can even express exactly what wishes, exactly what you want that healthcare agent and your healthcare providers to do for you. And you don't have to go through the conservatorship process either. That for financial decisions, there's a document out there called a power of attorney that in the first part, you can name your agent who's going to get to stand in your shoes and make sure that your creditors get paid, make sure that your bank accounts are topped up and distributed correctly so that your bills are getting paid. And you can also name the powers that agent is going to have in order to administer your finances, to handle your affairs if you're incapacitated. Um, Unfortunately, a will does not avoid probate. And I want to see in the chat if there's anybody who came into this thinking that probate would avoid, or that a will would avoid probate. I want to see that in the chat here. And I see actually, so somebody is outing themselves. If he had a will, why did it go through probate? That's a fantastic question. A will does not avoid probate. In fact, a will, if you're relying on a will to transfer your assets to the people that you love, that will has to be admitted to the probate court in order to administer that will. And I see somebody else saying, yes, I thought no probate. I assume for a will. Unfortunately, that's not right. A will has to go through probate. It's a testamentary document, which means that it doesn't actually go into effect until you're gone. So it has to be admitted, it has to be sent to the probate court to determine if the will is valid, to make sure that the person who you've nominated as the personal representative or the executor is capable of handling that role. And number three, review and make sure that that personal representative is administering the assets faithfully according to the will. And the probate court is overseeing and sitting in view of all of these things and making sure that it's all happening the way that it's supposed to through the will. So unfortunately, a will doesn't avoid probate, but probate is optional. And there's a great way to avoid probate. There's a great tool that we have for it called a revocable living trust. And I always like to do this demonstration. I hope that you don't mind zooming in on me here. The simplest version of a trust is this, that somebody starts with property and they entrust that property to somebody else called the trustee. And that person says, this is what I want you to do with that property that I've entrusted to you. And the trustee says, yes, I agree. I will use the property in the way that you've asked me to. I understand that it's not mine, but that I'm just going to control it and I'm going to use it for you on your behalf in the way that you've asked me to. That's the simplest version of a trust, right? That this person has entrusted it to this person who's going to use it for this person's benefit in the way that this person has written down instructions telling them how to use it. A revocable living trust, you are the person who starts with property, and you've entrusted that property to yourself as trustee, to yourself as the person who's going to control the property. And you've written the rules during your lifetime about what that property is going to be used for. If anything happens to you as trustee, if you pass away or if you become incapacitated before you pass away, a successor can step right into your shoes, governed by the provisions that you've written into your will. So that person can step right into your shoes and start administering your trust for you without any interruption. They can start and do it privately and do it more quickly and with less cost than having to go through the probate process. So that's what a trust is. That's what a revocable living trust is. Revocable means that you can choose to tear it up if you wanted to and have it no longer govern what happens with your assets. It also means that it's amendable. It's something that you can change during your lifetime. But once you've passed away, the rules that you've written during your lifetime are no longer changeable. They become irrevocable and unamendable at that point. They can no longer be changed. And now the successor trustee who's stepped into your shoes needs to faithfully follow what you've written in your trust and carry out your wishes regarding who your beneficiaries are and who's going to receive from your trust. Now I just need to figure out how to share my screen again. We've got it. Perfect. So that's what a revocable living trust is, and that's how a revocable living trust works. But one of the motions that I did in that demonstration, transferring the pen from one hand to the other, is really important, and it's something that has to happen for your trust to work the way that you want to. And that is fully funding your revocable living trust. And what fully funding your revocable living trust is making sure that all of your assets that start in your name are either transferred to your trustee during your lifetime or are directed to your trustee by beneficiary designation so that or pay on death designation so that at your death they go into your trustee's hands and your trustee has control over those assets so that they can handle those assets. So for real estate, that typically means recording a deed with the county recorder or with the registrar of titles, transferring ownership of that real estate into the name of your trust. For bank accounts, it typically means going to the bank and telling the bank, I want you to retitle this account, not in my name, but I want you to retitle this account in the name of my trust so that my trustee has control of it. And if a successor trustee ever comes along, you're going to know to expect them and to receive that and to receive them and make sure that they're able to access the assets in the way that I want them to. Investment accounts like brokerage accounts or mutual funds, it's the same thing. You're going to change title so that now they're in the name of the trust. Life insurance and retirement accounts typically have the trust as a beneficiary designation. Personal property goes over by a beneficiary or goes over by a bill of sale or an assignment of personal property. Things like furniture, clothing, jewelry, very easy to do with that assignment of personal property, putting those assets into the trust. I see somebody asking, can you name more than one person as trustee? And yes, absolutely. You can name more than one successor trustee who's either acting together with the successor or would be a backup to the successor in case something happens to the successor. I see somebody asking, how about a business? With a business, you can transfer your ownership in that business. For example, if it's an LLC, you can transfer your membership interest, your shares, into the trust or into the name of the trustee. It's not a problem. If you're a sole owner of your business, it's very easy because you're typically the person who needs to approve this transfer. If you're not a sole owner of the business, then we just need to make sure that the secretary can authorize this transaction, and we need to read the rules of the business to make sure that the transfer into a trust is permitted. And even if it's not immediately permitted by the provisions, typically once you explain to the business what you're trying to do and how you're trying to do it, we can get it approved and get it transferred over. That the secretary has the name of the trustee on the documents showing membership interest. And by doing that, it makes sure that your successor trustee can step in right away and access that membership interest and sell it if they need to or do whatever they need to with it. So that's a fantastic question. Thanks for asking the great question here. Couple other things. What about estate taxes? A lot of times when I help people plan, they're very concerned about what is the state going to ask me to pay or ask my loved ones to pay? What is the federal government going to ask me to pay? And that is a really fantastic question. There are, unfortunately, some bad news is that there is a federal estate tax and there is a Minnesota estate tax, both. But the good news is, excuse me, those estate taxes don't kick in until you get to a pretty high level of wealth. On the federal level, you have to have more than $13.99 million, and any exemption is portable with a spouse. That means that if you are married, that $13.99 million is doubled. You get your spouse's exemption as well. So it's almost $28 million that you can pass without having it be subject to any federal estate tax. And that's good news because the federal estate tax rate is extraordinarily high. In fact, it goes up to 40%, which is a huge bite out of your estate if you're starting to have federal estate tax apply to your estate. In Minnesota, we also have an estate tax. The exemption amount is high at $3 million, but we're seeing more and more people that are becoming subject to that Minnesota estate tax that at that exemption point. And unfortunately, in Minnesota, that exemption amount is not portable to your spouse, which means you have to do some planning in order to preserve if a spouse passes away, to preserve some of your assets, to preserve some of that exemption amount. You have to take advantage of it when the first spouse passes away. You can't automatically double that number the way that you would be able to under the federal estate tax picture. The rate here in Minnesota is lower. It's something like 13 to 16%, but something to keep in mind, something that's really important. If you're above that $3 million number, you really need to be planning with an estate planning attorney to minimize those estate tax issues. And this is just a caution point that I want to make sure that everybody knows. If you know somebody that you want to have inherit money from you, but that person is receiving some kind of government benefit because they have a disability or because they have special needs, um, giving them that inheritance directly could be more harmful than helpful to them. In fact, this not only applies to people with special needs, it also applies to minor children. That having assets go directly to a minor child and not be held in some kind of custodial account or in a trust can be exceptionally difficult for that child to receive. And in fact, may require a case or a process called conservatorship to oversee the assets for that minor. Conservatorship is like probate, but it's much more expensive and has with it an ongoing obligation to make accountings with the court for that conservator about how they're using the money. But with special needs, with somebody who's receiving benefits from the government, receiving an inheritance can be extremely destabilizing because it can knock them off of that government benefit. For example, if they're able to live in a group home and they enjoy that group home or they enjoy that subsidized housing and wouldn't want to leave there, handing them an inheritance, you might think that you're making their life better, but it could really destabilize them. It could disqualify them from that group housing potentially, or could make it where they need to find a new place to live. And then as soon as the inheritance that you've given them is out, they may have to reapply for that government benefit, which can take time to qualify for and can create delays and potentially gaps in coverage. So something to be very cautious about here. So we've talked about a lot of things today. We've talked about guardianship for minor children, and I understand not everybody has minor children, but if you don't have minor kids, it might be something that's worth mentioning to people that you love who may have minor children. We've talked about uh, we've talked about planning for incapacity and the fact that the court may need to make a decision about who can make healthcare decisions for you or who can make financial decisions for you. In fact, for healthcare decisions, many of us remember a case about a young woman called Terry Schiavo. And Terry Schiavo suffered a cardiac event and was left in a vegetative state. And there was a disagreement between her husband and her parents about the kind of care that Terry should receive. Her husband thought that life-sustaining treatment should be removed from Terry and she should be allowed to pass away. Her parents wanted her to continue receiving that life-sustaining treatment. After a series of court cases, the life-sustaining treatment was removed, and Terry passed away about 2 weeks after that decision was made to finally remove the life-sustaining treatment. But all of that court, all of that conflict was under the guardianship type of court case. And I can't even imagine how expensive, how much that ran in attorney's fees, how much division that created in the family and with that husband of the late Terry Schiavo. We talked about conservatorship a little bit, and we talked about that you can document your healthcare decisions in a healthcare directive. You can document your financial decisions and who you want handling financial decisions for you in a power of attorney, and that you have that power. We talked about probate, and we talked about the fact that probate takes a long time to go through, at least 6 months, oftentimes more like 12 or 18 months. We talked about the fact that it's an expensive process, costing something like 3 to 6% of the gross value of your estate. That probate is also public. We talked about the fact that the court believes that the public has an interest in transparency and an interest in knowing what is happening in the probate court. And that means that they publicize information like your assets and like who's receiving those assets after you're gone. We talked about the fact that a will, unfortunately, does not avoid probate. If you're planning your estate with a will, and that will is really the linchpin that's going to transfer your assets to the people that you want to receive, probate is required to probate that will, to administer that will. It has to go through the probate court case. And we talked about a lot of people prefer not to do that. And the good news is probate is avoidable. You can avoid probate. And one good way to avoid probate that works for a lot of people is by fully funding a revocable living trust. It's not the only way, but it is a good way for many people to avoid probate. And it's something that we talk about in the course of estate planning when we talk with our clients. We talked about estate taxes here tonight, and the good news is that estate taxes don't apply to most people. The bad news is that there are estate taxes, and unfortunately, they do apply to some. If estate tax seems like it may be an issue to you, I strongly encourage you to reach out to me and we can talk about how we can plan to minimize that estate tax if anything should happen to you. We also talked about what did we just talk about? We talked about special needs and having minor beneficiaries receive, and how it can be a really harmful thing. It can be a really bad idea to have somebody with special needs or a minor child to receive. In the midst of all of this conversation, something probably jumped out to you that makes you think, you know what? I do want to get this taken care of. It is time for me to get a plan in place and take care of it, which probably leaves you at a crossroads. You're probably thinking, how do I take the next step forward? Is this something that I can attempt to do myself, or is it time that I bring in an expert? Is it time that I hire an attorney to make this process simple for me? And if I'm going to hire an attorney, what kind of an attorney should I be looking for? Who should I be hiring? Well, I really want to caution you against trying to DIY your estate plan. To do your estate plan yourself can lead to disastrous results. And I always like to tell this story of a DIY project that I did that ended in a disaster. And if somebody wants to pitch in and tell me what I did wrong in the chat, I still haven't had anybody tell me what I did wrong. But essentially, what happened is this. I ordered a couple of fishing rods. My son was really young. I think he was about 5 at the time, and I wanted to take him fishing. So I ordered a couple of fishing rods, and they came. They were delivered to me without any fishing line on the rod. No problem. I ordered some fishing line and went down to the basement and set them out on the table the morning that we were going fishing, and I wound some fishing line onto each of the rods. And just as I was finishing with the second rod and I had wound that reel up full of fishing line on the second rod, I went and snipped the line at the end of the fishing pole. And all of a sudden, the fishing line started jumping off of the reel all over the table in front of me, and I had this giant tangled mess, just like the tangled mess that you see on the slide in front of you. Again, I still don't know what I did wrong. If anybody, any fishing experts could let me know what they suspect I did wrong, I'd really appreciate it. I had this huge mess on my hands, and I wanted to take my son fishing that morning. Um, but you know what? That was a do-it-yourself project that was okay to fail at because I was able to fix that fishing rod, that fishing line that morning. I had to snip off some tangled, unusable fishing line. Unfortunately, I maybe lost something like 35 cents worth of fishing line at the high end, if I even lost that. But I was able to get it fixed that morning and still able to take my son fishing. I like to tell that story because it's almost exactly the opposite of estate planning. Trying to DIY your estate plan is the exact opposite of trying to DIY winding fishing line onto your fishing rod. Estate planning is extremely complicated. I've heard somebody explain it as trying to put together IKEA furniture without the instructions. So there's lots of moving pieces, and it's hard to know how they all fit together than to see the big picture unless you have expertise, unless you have experience practicing in the area. If you make a mistake in your estate plan, you unfortunately are not going to be the one to fix that mistake. In fact, that estate plan is going to go into effect at a time when your family is grieving and hurting and missing you and wishing that you were there to make it all better. And you're not going to be there to make it better at that point. They're going to be relying on that estate plan to carry out your wishes and to make sure that they're doing what you want them to do. So if you make a mistake, you're not going to be able to fix it. And I can tell you, if you make a mistake in your estate plan, you're going to be spending far more than 35 cents. It's not just some fishing line that's going to be lost and need to be discarded. In fact, if your estate plan can even be fixed, you're probably going to be looking at thousands of dollars in attorney's fees and a lot of conflict and a lot of discomfort and fighting in your family to try and make your estate plan what you initially wanted it to be. So I really counsel people, if you own more than just your vehicle, if you own more than just some personal property, I strongly encourage you, do not try and DIY your estate plan. It is worth hiring a professional. Just like if you're have a water leak and you decide to open up your wall and work on your pipes, I would probably recommend before you seal that up, have somebody with some good sense, maybe a professional, take a look at those pipes because if they start leaking again inside of your wall, you might have a real mess on your hands. Estate planning is the same way. You're not going to be aware that you made a mistake at the time that you made the mistake. And when you have to go and fix it, or when your family has to go and fix it in the end, it's going to be extremely costly. So that probably tells you, should you be doing your estate plan yourself? Probably not, unless your assets are pretty limited. So what should you look for in an attorney? Well, my recommendation is that you look for an attorney who understands that the estate plan isn't just in the four corners of the document, that the estate planning attorney is somebody who understands that you want a specific value out of your estate plan, somebody who specializes in and focuses their work on just writing estate plans or related fields like handling probate, handling trust administration, and taking care of those things because those are really related and similar areas to practice in. But I strongly encourage you to choose an attorney who's going to make sure that your wishes are carried out and that the value that you want, avoiding court and conflict in your family, making things as simple and as easy as possible for your family is the objective that they have on their mind and that they're going to take care of. I recommend that you find an attorney who charges flat fees so that you know exactly what the fee is when you first meet with that attorney before you even have to sign a document with them saying that you're ready to hire them as your attorney. And that's something that I do. Obviously, I'm looking beyond the four corners of the document. I understand how to make an estate plan work. I only charge flat fees. They're fixed fees, and you're going to choose your own fee. Typically, my fees range somewhere between $2,500 and $6,000. And I understand that's a significant cost. But if you reflect back on what probate costs, if all you have is a house that's worth $400,000, the low end estimate for probate is going to be $12,000 to get your estate through the probate process. That's 3% of a $400,000 house. So, hiring an attorney who you are confident is going to get your estate plan right, is going to make things simple and easy for your family, is really a cost savings in the long run, in addition to being a gift for your family. Um, and I want to make this easy for you. I want you to reach out to me. I want you to use me as a resource in order to get your estate plan the way that you want it to be. Um, give me just a second. Uh, and I'm going to post in the chat the link where you can find my schedule online because I want to offer you some things here. One of the things that I want to offer you is a free family wealth planning session with me. And you'll see spots there at that link in the chat box right now where you can book a free family wealth planning session with me, which has a $750 value. This is a $750 value because it's a 2 hour long meeting with me where we're going to talk about the things that you have and we're going to talk about the people that you love. And we always talk about right now, what would happen if something happened to you? What's the process that your assets would have to go through? What's the process that your family would have to go through if something happened to you? And then we talk about what is it that you want to have happen? What would be the ideal situation for your family if you could wave a magic wand and make it happen? And then we talk about the different estate planning tools that we have that we can bridge that gap, the gap between what your estate plan is now and what you want your estate plan to be. And those tools that we're going to use for you, that we're going to use to plan your estate, help to answer and help to detail for us exactly what the cost is going to be and what the timeline is going to be to execute your estate plan for you. And that's really what gives us the picture of what the cost is going to be and how we're going to be able to move forward. And as we share that with you, as we share the cost with you, as we share what we expect the process to look like, you can make the decision. Is this somebody that I want to hire? Is this somebody that I trust to take care of my estate planning for me? Are they going to make sure that my wishes get carried out? Are they going to make sure that my family has a simple process and an easy process to follow? Are they going to make sure that my healthcare wishes are documented in a way that they're going to be honored and followed by my healthcare providers and by the person that I want making healthcare decisions for me? Am I going to make sure that I have somebody in place that can handle my finances, that can make sure that my creditors continue to get paid, that my bills continue to get paid if something happens to me? I want to be that person for you. I want to be that attorney who can help you to get those things into place so that you know exactly what your estate plan says and exactly what it means for your family if anything should happen to you. And I don't want to just give you that estate planning meeting. I want to give you that initial estate planning meeting so you can have clarity on your finances. You can have clarity on exactly what your plan says right now. But I also want to give you $250 towards the estate planning package of your choice. And I want to give that to you as an added gift as long as you'll do me a favor here. I want you to book your meeting with me, your family wealth planning session, before the end of the week. Now, if you look at my calendar, you're going to see I don't have any more times to meet available in January. I'm booking out into February, and my guess is the dates there may start to be getting a little bit picked over as people are able to open up the link to the schedule and find a time that works for them. you're not going to be able to schedule to actually have a meeting with me before the end of the day on Saturday here this week. No, but I do want you to reserve your meeting spot, whether that's in February, whether it's in March or April. I want you to book that time to meet with me here before the end of the week. And here's what that's going to do. It's going to mean that I need to do a little bit less follow up with you to make sure that you're ready to make the next step. And for you, it's going to help you continue the journey in getting an estate plan in place and getting this taken care of and checked off your to do list here for 2025. It's a win win situation. All I'm asking you to do, I'm not asking you to put money down for the meeting. I'm not asking for you to open up your wallet or anything like that. I'm just asking for you to reserve the time that I want to give you to have this conversation and to continue to learn about estate planning and learn in particular what it means for you and your assets and your family. And I want you to do that before the end of the day, Saturday. And I'm happy to give you the $250 towards the plan of your choice if you'll do that. The family wealth planning session is just a great way to continue our conversation. And I will watch here in case anybody wants to. Now is a great time to ask questions in the Q&A box or through the webinar chat if you have any specific questions that you want answers to. I will watch here and be sure to answer those questions. I think we also had some questions that came through before our meeting here, and I can ask some of those questions as well. One of the questions that I see coming through the chat here is it possible to do estate planning with the father of my child together without being married? And the answer is yes, that we can do that kind of planning. We can work together to figure out an estate plan together. Things are a little bit complicated, more complicated if you're not married. There are certain advantages to being married, including something called a marital unlimited deduction, meaning you can transfer as much in assets at any time that you want to somebody that you're married to, that isn't available to people who aren't married to each other. But we know that. And we're able to plan for that, and we're able to account for that. And so it's okay if you're not married, but you want to get started on estate planning and you want to get started to make sure that your child is taken care of. We can help you, and I hope that you'll reach out, and I hope that you'll schedule a meeting with me. Some people I know before our call here today, before the webinar, were curious about trusts and we're curious about estate planning. And I hope that I've been able to speak to, and I hope that I've been able to answer some of those questions maybe that you had coming into this. A trust is a great estate planning tool. Like any tool, it's not the perfect tool for every job. Sometimes we look at other estate planning tools and we're able to use things like beneficiary designations or transfer on death deeds in order to accomplish what we want to in an estate plan. But a lot of times, a trust really is just a fantastic tool. And so a lot of times we do utilize trusts in order to avoid probate and make things easy for our family in case anything happens to us. I know somebody else had mentioned before our meeting when we reached out to them that they didn't have any particular questions. They just know that they need to get one done. And it's true. We all should have an estate plan in place. In fact, if you're above the age of 18, there's at least some foundational estate planning that you should do. That healthcare directive and power of attorney are pretty essential, and making sure that you have beneficiaries set up so that if anything happens to you, they're going to go the way that you want them to. I see somebody saying, I did make an appointment with you, and I'm really looking forward to meeting with you. That they have some things in place right now, but not anything that will really protect their hard work. Yeah, and it is important. You know, we work really hard, we save, we want to make sure that those assets are going to the people that we love in a way that they're going to be able to receive them in an inheritance. And this is just finishing that last part of the race, right? It's making sure that you have checked off the last thing that you need to check off so that your hard effort is going to benefit the people that you want to benefit. It's not going to be a hindrance to them. They're not going to have to go through a difficult court process like the process of probate, but it's going to be taken care of and easy for them. I see somebody else asking if one has a will already, can it be used for a revocable living trust, or do we need to start from scratch? And the answer to that question is typically, if somebody has a will in place already, we are going to be rewriting that will with something called a pour over will. And a pour over will is just a very simple will. It says if I have any assets that are in my name at my death, put those assets into the name of my trust and let my trustee govern those assets and control them and detail what happens with them. So unfortunately, a lot of times we can't pull that will forward and make use of that will. Again, we don't want to be relying on that will for its estate planning purpose. We just want it to be a backup to our trust. So a lot of times, even if you have a will in place already, we're going to be updating that. Even if you have healthcare directives and powers of attorney in place already, a lot of times I want to review those and make sure that they're doing what you want it to do. And a lot of times we are just updating those documents because it makes sense to update them at the same time that we're updating your will and your trust. Does my house need to be completely paid off to be included in a trust? That's a fantastic question. And the answer to that is no, that we can transfer a house into a trust even if there's still a mortgage on that house. And there's a provision, there's a law called the Garn St. Germain Act that says that a mortgager or a lender cannot accelerate the mortgage on that house just because you've transferred it into a revocable trust. So we have protection for that. We're able to take care of that. We're able to transfer a house into a revocable trust without a problem, and doesn't have to be paid off in order to do this kind of planning. I see someone else saying that they have a daughter who has special needs. She's autistic, and that they're worried about her. And I'm sorry, this is a question from before our meeting here. But they don't want to set up a special needs trust, but they are in the process of getting guardianship set up for that. That's that daughter who has special needs. A special needs trust isn't necessary if the person isn't receiving government benefits. That if a person isn't receiving government benefits, maybe they have some income already coming in that they're able to live off of and they're able to sustain themselves off of, or maybe there's just some family money that's going to be able to provide a living for that child. Then it's possible that we could structure that without a special needs trust, without having to have any kind of reliance on some kind of government benefit in order to pay for it. But I would say if that's the case, you're really going to want to make sure that you do some planning and that you have a complete picture of things and that you've taken care of it so that they're not uh, um, in any kind of trouble. I see somebody saying that they know me from back at the law firm that I worked at when I just came out of law school, and don't have things in line right now. And that's fantastic. I hope that you'll reach out. I hope that you'll schedule with me. And I'm glad that you remember me from that first law firm that I worked at. I see somebody asking, does putting your home into a trust affect your homeowner's insurance? That's a great question too. If you put your home into your trust, it's my recommendation that you reach out to your insurance company and let them know that you've made the transfer, and they will update their records to add the trust as a third party on your insurance. So it is important to let your home insurance company know that you've made that transfer. You're no longer the owner of your property, but now that property is in a trust. And that makes sure that the insurance stays on the property, that it stays insured, and if there's any incident or any accident that happens on the property, that insurance does get paid, and they're aware that the transfer has happened. I see somebody asking, is a trust safe in a divorce settlement? And I think that question, I could probably construe that question in a couple of ways. Does a trust stay in place after somebody is divorced? Typically, if it's a joint trust that you've created with your spouse, you would need to write new estate planning documents after the divorce. That's just the nature of things. If you've written a joint trust together, you're probably going to need to write a new trust. Another question another way that could be construed is, are the assets in the trust protected from my divorcing spouse? And the answer to that is it depends on the character of the assets that you're putting into that trust. If you have a separate trust that is always and only held separate assets that didn't come from your spouse, that weren't created or weren't, didn't come into the marriage during your relationship with your spouse, that maybe they were just inherited, for example, and immediately went into your trust, then those assets may not be part of the divorce settlement. Um, but it depends on the situation. But typically, if you've created assets together, or you've saved and you've saved some money and set it aside during your marriage, and the money initially came from one or both of your paychecks, then that money probably isn't going to be safe just putting it into a revocable trust. It doesn't have an asset protection character like that. That a divorce settlement is going to want to look at all of the assets of both couples, and make sure that things have an even or a relatively equal split. Someone else is asking, does the trust affect my children's income level? And that's a fantastic question. It really depends on how the trust is written, but typically, yes, a trust may affect a child's income level if it's paying out. So that would require that you had passed away and they received that money as an inheritance, and it depends on their access to that money, whether it's something that they would need to claim, for example, on FAFSA. And there are certain ways that we could write it where it would need to be claimed on FAFSA. There are some ways that we might be able to write it where it wouldn't need to be claimed on FAFSA for them. But that's an interesting question. It's a good question. Another question: can you put vehicles into a trust? The answer to that is yes. Here in Minnesota, we can transfer vehicles into the trust by filling out title paperwork with the Department of Vehicle Services to transfer that title out of our name and into the name of our trust. And the Department of Vehicle Services is pretty aware of that process and is able to handle it. It's not something that we do with every estate planning client that we have and every trust that we have, because there is a threshold for probate in Minnesota. And that threshold is, if you own any real estate in your name at your death, then you have to go through probate, as long as that real estate wasn't owned with joint interest or with a transfer on death deed on it. But if you just have that real estate in your name at your death, then probate does have to happen. Or if you have assets in excess of $75,000, then probate needs to happen. So there's that $75,000 threshold that you have to be above in order for probate to be necessary. And oftentimes for our clients, we find that their vehicle, the ownerships of their vehicles, falls below that $75,000, but not always. And so sometimes we do transfer those vehicles into the trust, and there is a process, like I say, with the Department of Vehicle Services to make that happen. Somebody else during our initial outreach had said that they were didn't have any specific questions, or just starting to think about estate planning. And hopefully I've been able to educate people a little bit here, and start their conversation and start their thinking about estate planning. I see somebody saying they read the book Wear Clean Underwear, which looks like it's directed towards younger families. And yeah, that's exactly right. If you want a free copy of that book, Wear Clean Underwear, go ahead and reach out to me. It was written by one of my mentors, Alexis Neely. It's a great book. It really is focused on younger families who have concerns about things like guardianship. But I plan for lots of people. I help lots of people with estate planning, not just people with young kids in guardianship. In fact, I would say that most of the people that I help with estate planning, the kind of the typical demographic tends to be just into early retirement. That it feels like that's the time when a lot of people say, okay, now I'm ready to write my estate plan. I'm ready to write my forever estate plan. That maybe they worked on guardianship and a simple will back when they were just a young family and had just been starting out. But that early retirement age, a lot of times people are ready to get their forever plan in place. And we're really happy to help you do that and help you get a plan in place that's going to take care of you. Yeah, you bet. Um, Somebody else in our outreach before the presentation here said that they have a son with a mental disability and that they don't know how to pass things to him and that they're uneasy about that. That they don't have a lot of assets, but that they own their house. And like we kind of talked about, people who have special needs, it can be really challenging. A lot of times, if it's a special need that doesn't necessarily rise to the level of needing a government benefit like a subsidy for housing or a subsidy for healthcare, that they're maybe able to kind of work independently. But uh, um, maybe we still have concerns about how they're going to handle an influx of money. Or people with, sometimes we talk about lifestyle disabilities, things like issues with substance abuse or issues with gambling. And we have concerns about how we're going to leave money to those people that we love in our family who have those kinds of issues in their lives. There are lots of options that we can explore about having a guardian in place to oversee or having a trustee in place who's going to oversee the money that you want that person to enjoy and make sure that they're enjoying that money, that they're not using it for self-destructive purposes. And we can definitely help with that. We can definitely help writing provisions to make sure that people are well cared for from the inheritance that they're going to receive. Um, I have somebody else who is interested in finding more information about the best ways to do things, maybe doing a trust or just doing things in general, how to protect investments as we get older. And that's a great question. A question that hasn't come up here tonight, but I often get is how do you plan for things like the nursing home and plan for how to protect things in case that becomes necessary in the future. And I do help with that. It's difficult and it's complicated. And it can lead to situations where maybe you have to give up some of control of your assets. But there are great ways to plan for the nursing home and to plan to make sure that you have an inheritance that's going to go to your kids. In addition, there are some really foundational things, making sure that you have somebody who can make healthcare decisions for you if you're starting to go through the process of Alzheimer's or ALS or Parkinson's, and you need somebody who can step in and help you with healthcare decisions and help you to make sure that your bills are continuing to be paid. That we can help with that, and we can help to make sure that your wishes are documented legally and that your wishes are going to be carried out. So those are really important things. Have just a little bit more time here. If anybody else has any questions that are coming up in their mind, glad we were able to get the chat working here. I can't believe that was an issue all the way at the beginning. I see somebody asking how much additional cost would there be to make changes to a revocable trust as life circumstances change? Yeah, that's a fantastic question. We want to know, if something changes, if we have another child or if we decide that we want a different trustee in power to handle things if something happens to us, how much are those types of changes going to cost? And it's a fantastic question. Uh, it really depends on the kinds of changes that you want to make. But I can tell you, we at the law office of Timothy J. Scott, we have a philosophy of really targeting those decisions and making them in the clearest and smallest way possible, with the least amount of time, the least amount of administration, making it as simple as possible, just taking care of it for you, and estimating what that cost is going to cost and talking with you and agreeing on a flat fee before we actually make that change, so that you know exactly how much it's going to cost in order to make the change. Sometimes we talk to people about the necessity of making changes. So I mentioned, maybe you have a new child and you want that child to be added to the trust or you want them to be named in the will. the way that we write our trusts and the way that we write our wills, make sure to include any future born children that you might have. So strictly speaking, it's not necessary to list that new child in the will or the trust. And we talk about that when we meet together and we say, legally, you don't have a need to add this new child's name and date of birth. In fact, I'm not sure that I have my some of my maybe two of my newest children listed in my estate plan. Which I can do that without any cost, but it's not strictly necessary. And so we talk about, is this strictly necessary, and how do we want to do this, and what should the cost be? And we just are very fair in our fees and make sure that it's a reasonable fee that we're charging in order to take care of it. See somebody else asking, is it wise to use a fiduciary rather than a family member or friend? It's really dependent on the situation. There are some great fiduciaries out there who do this stuff day in and day out and are very familiar with it and take care of it in a really efficient and really careful way. And they can be a great resource, but they can also be pretty costly. I know there's a fiduciary that I like to use that will serve as a trustee, that will serve as an attorney, in fact, under a power of attorney, will serve as a healthcare agent, but they charge something like $175 an hour. And that's actually that's on the lower end of fees that you might be charged. That there are banks that will serve in that role, but especially in the role of trustee, but typically they charge a percentage of fees, and it can be very expensive to hire those banks in order to administer things. So it really depends on your situation. If you don't have a perfect person to name, then a lot of times it does make sense to bring in a fiduciary because we know they're going to do things in the right way and in a fair way. They're a third party coming from the outside. But typically in almost every plan that we write, I would say in something like 90% of plans, we are relying on family and we're relying on friends to carry out our wishes for us. And it just seems to be the best way for most of our clients to plan their estate. I see somebody else saying, thank you for the time and explanations. Very happy to help and very happy to be here with you this evening. So thank you for joining me. I am not seeing any other questions coming through. Hopefully you've had the time to click through the link and find some time to meet with me. I'm very much looking forward to meeting with you and continuing this conversation and helping you in any way that I can. I think it's probably come through. I love this stuff and I love helping people to plan their estate and to get a great estate plan in place. And that is the next step. The best next step for you right now is to reach out to me and continue the conversation with me so that we can get this taken care of. We can get it checked off here early in 2025. You can write a great estate plan. We can help you to take care of it. And I hope that you'll reach out to me. I look forward to hearing from you. Have a great evening, everybody. Thank you again for reaching out to me, and we'll talk soon.